Hello, I am Nurul Athar, PMP, CPHIMS-CA Chartered Certified, and welcome to CPHIMS-CA Exam Prep Domain Canadian Healthcare System, Part 4. In Part 4, we are going to explore privacy and security. So, let us start privacy and security. Under privacy and security, we are going to explore what is personal information. Canada has two federal privacy laws that are enforced by Office of the Privacy Commissioner of Canada: right to access personal information, deny access, making complaint, and provincial privacy laws. So let's explore one by one. First we'll see what is personal information. What is PHI? PHI stands for Personal Health Information. Personal health information includes oral or written information in any format that identifies an individual and relates to their health and healthcare. Some examples might include your address, your health card number, your medications, laboratory test results, and examination notes. While your information is held by an institution or someone other than yourself, the information contained in the record is yours and you have the right to access it. However, the physical record is the responsibility of the person or organization that created it. Personal health information is precisely that: personal, as the owner of your health data consent for sharing it rests with you. Just as banks protect financial information, it is important to ensure that health data is kept private and secure. Now let's see what is PIPEDA. Under PIPEDA, personal information include any factual or subjective information recorded or not about an identifiable individual. This includes information in any form such as age, name, ID numbers, income, ethnic origin or blood type, opinions, evaluations, comments, social status or disciplinary actions, and employee files, credit records, loan records, medical records, existence of a dispute between a consumer and merchant, intention, for example, to acquire goods or services or change jobs. Now see, protecting personal health information. Data are valuable commodity in our digital world, and health data is no exception. Read how the provinces and territories, health providers and vendors work together to keep your health data private and secure. Canada has two federal privacy laws that are enforced by the Office of Privacy Commissioner of Canada. The first is the Privacy Act. Second one is Personal Information Protection and Electronic Document Act, PIPEDA, which is stand for Personal Information Protection and Electronic Document Act. Okay. Then we'll explore how the act applies. What is not covered by PIPEDA? Your responsibilities under PIPEDA. The Privacy Act defines personal information as any recorded information about an identifiable individual, include race, national or ethnic origin, color, religion, age or marital status, education, medical, criminal or employment history of an individual, or information about financial transactions, any assigned identifying number or symbol, address, fingerprints or blood type, Personal opinions are views except where they are about another individual or about a proposal for a grant, an award or prize to be made to another individual by a government institution. Private or confidential correspondence sent to an government institution. The view or opinion of another individual about the individual. The views or opinion of another individual about the proposal for a grant, an award or prize to be made to the individual by an institution. The name of the individual where it appears with other related personal information or where the disclosure of the name itself would reveal information about the individual. Now see what is not included. For certain provision of Privacy Act, personal information does not include certain professional information about an individual who is or was an officer or employee of federal government, certain professional information about an individual who is or was performing services under contract for a government institution that relates to the services performed, certain information related to any discretionary financial benefit including the granting of licenses or permits to an individual, information about an individual who has been dead for more than 20 years. Now see which covers how the federal government handle personal information. It's mean the Privacy Act, which covers how the federal government handle personal information. The Privacy Act is the law that set out your privacy rights in your interaction with federal government. It applies to how the federal government collects, uses and discloses your personal information. The Privacy Act protects your personal information that government institutions hold. The Act also gives you the right to access your personal information held by the federal government. Now see where the Privacy Act applies. The Privacy Act applies to government collection, use, disclosure, retention or disposal of personal information in the course of providing services such as old age, security benefits, employment insurance, border security, federal policing and public safety, tax collection and refund. Now see, the Act applies to federal government institutions listed in the Schedule 3 of the Privacy Act as well as to Crown corporations. All provinces and territories have laws regarding their public sectors. The Privacy Act does not apply to political parties, political representative, that is a member of parliament and senators, courts, private sector organizations. Now we will explore Personal Information Protection Electronic Document Act, PIPEDA, which cover how businesses handle personal information. There are a number of requirements to comply with the law. Organizations covered by PIPEDA must generally obtain an individual's consent when they collect, use or disclose that individual's personal information. People have the right to access their personal information held by an organization. They also have the right to challenge its accuracy. Personal information can be used for the purpose for which it was collected. If an organization is going to use it for another purpose, they must obtain consent. Again, personal information must be protected by appropriate safeguards. Now we'll see how Act applies. PIPEDA applies to private sector organizations, across Canada that collect, use or disclose personal information in the course of commercial activity. The law defines a commercial activity as an particular transaction, act or conduct or any regular course of conduct that is of a commercial character, including the selling, bartering or leasing of donor, membership or other fundraising list. Provincial privacy laws. Alberta, British Columbia and Quebec have their own private sector privacy laws that have been deemed substantially similar to PIPEDA. Organizations subject to an substantially similar provincial privacy laws are generally exempt from PIPEDA with respect to the collection, use or disclosure of personal information that occurs within that province. Ontario, New Brunswick, Nova Scotia and Newfoundland and Labrador have also adopted substantially similar legislation regarding the collection, use and disclosure of personal health information. Now see information that crosses borders. All businesses that operate in Canada and handle personal information that crosses provincial or national borders in the course of commercial activities are subjected to PIPEDA regardless of the province or territory in which they are based, including provinces with substantially similar legislation. Now see federally regulated organizations. Federally regulated organizations that conduct business in Canada are always subjected to PIPEDA. The Act also applies to their employees' personal information. These organizations include airports, aircraft and airlines, banks and authorized foreign banks, interprovincial or international transportation companies, telecommunication companies, offshore drilling operations and radio television broadcaster. Now see what is not covered by PIPEDA. Remember, PIPEDA stands for Personal Information Protection and Electronic Document Act. There are some instances where PIPEDA does not apply. Some examples include personal information handled by federal government organizations listed under the Privacy Act, provincial or territorial governments and their agents, business contact information such as an employee's name, title, business address, telephone number or email address that is collected, used or disclosed solely for the purpose of communicating with that person in relation to their employment or profession. An individual's collection, use or disclosure of personal information is strictly for personal purpose, for example, personal greeting card list. An organization collection, use or disclosure of personal information solely for journalistic, artistic or literary purpose. I'll read again. Artistic or literary purposes. Unless they are engaging in commercial activities that are not central to their mandate and involve personal information, PIPEDA does not generally apply to not-for-profit and charity groups or political parties and associations. Municipalities, universities, schools and hospitals are generally covered by provincial laws. PIPEDA may apply in certain situations. Now see your responsibilities under PIPEDA Act. Businesses must follow the 10 fair information principles to protect personal information. which are set out in Schedule 1 of PIPEDA. By following these principles, you will contribute to building trust in your business and in the digital economy. The principles are: number 1, accountability, identifying purposes, consent, limiting collection, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access, challenging, compliance. Now we will explore requirements for handling personal information. Under this we are going to learn about collection, use, accuracy, retention and disclosure. So let us start with collection. According to Privacy Act, a government institution can only collect your personal information if it is directly relates to the operation of one of its program or activities. A government institution must collect this personal information directly from you whenever possible, unless you authorize otherwise, or it is one of situation specifically mentioned in the Privacy Act that allows for a government institution to disclose your personal information to another institution. A government institution must normally inform you about why the information is being collected, unless informing you about why it is being collected might result in the collection of inaccurate information, defeat the purpose for which the information was being collected, or prejudice its use. For example, if an individual is facing criminal investigation, now see use. Unless you consent to other uses, the government may only use the personal information for the purpose for which it was collected, or use consistent with that purpose, or other specifically identified purposes listed in the Privacy Act. That's the accuracy. A government institution must take all reasonable steps to ensure that personal information it uses about you is accurate, up to date and complete as possible. Retention. Your personal information that has been used by a government institution for an administrative purpose must be retained for at least 2 years unless you consent to its disposal. If you make a request for access to information, it must be retained until you have the opportunity to exercise all your rights under the Act. Disclosure. Personal information under the control of a government institution cannot be disclosed without your consent except in specific circumstances, such as for the original purpose for which the information was collected or used consistent with that purpose, where the disclosure is authorized in federal legislation, to comply with the subpoena, warrants or order of court or another body with the authority to compel information, where disclosure would clearly benefit the individual, where the public interest in disclosure outweigh any invasion of privacy. Now we'll explore right to access personal information. All Canadian citizens and permanent residents may access any personal information about themselves under the control of a federal institution. To request access, you must make a written request to federal institution that holds your personal information. The request must provide enough specifics about the information so that it is reasonably retrievable. Such specific could include related government program and date the information was collected, for example an employment insurance claim from 2014. There is no charge to request access to your personal records. Ordinarily, the institution has 30 days to respond to request for access. However, this deadline can be extended in limited and specific circumstances when meeting the original deadline would unreasonably interfere with the operations of the government institution. Consultations are required to comply with the request that cannot be reasonably done within the original deadline. Time is required for translation or to convert the information into an alternative format. Once the institution grants you access to your personal information, you can check that it is accurate and complete. If it is not, you can send a completed record correction request form to the institution to ask that correction. Additions or deletions to be made. Where a requested correction is not made, a note may be added to the personal information to set out the individual's views on the matter. Now see denying access. Under some circumstances, the government institution may deny access to your personal information. Some examples include disclosure of information could harm federal, provincial or international affairs or defense of Canada. The personal information was obtained or prepared by an investigative body specified in the regulations. The disclosure of information could reasonably be expected to threaten the safety of an individual. The information is subject to solicitor-client privilege. The information relates to your physical or mental health, where the examination of the information would be contrary to your best interest. Making a complaint. When a privacy issue arises, your first step should generally be to try to resolve the issue directly with the institution. You can raise your concern with the Access Information and Privacy (ATIP) coordinator of the institution responsible for the personal information at issue. You can find a list of ATIP coordinators by institution on canada.ca. You can also obtain this information by contacting the institution directly. If you are not satisfied with the outcome of the access request, you have the right to file a complaint with our office. Our office can accept complaints about the personal information handling practices of federal institutions. Subject to the Act, you can file a complaint if, for example, you feel your personal information has been inappropriately collected, used or disclosed. You were refused to access to your personal information. You feel there was an unreasonable delay in getting access to your personal information. Now I will go see provincial privacy laws. Every province and territory has its own laws that apply to provincial government agencies and their handling of personal information. Some provinces have private sector privacy laws that may apply instead of PIPEDA. This means that those laws apply instead of PIPEDA in some cases. These provinces are Alberta, British Columbia and Quebec. Alberta, British Columbia and Quebec. Now see health related. The following provinces have health related privacy laws that have been declared substantially similar to PIPEDA with respect to health information, like Ontario, New Brunswick, Newfoundland, Labrador, Nova Scotia. While other provinces and territories have also passed their own health privacy laws, these have not been declared substantially similar to PIPEDA. In some of those cases, PIPEDA may still apply. Now see employment related. Some provinces have passed privacy laws that apply to employee information. Examples include like Alberta, British Columbia. Each province and territory in Canada has a commissioner or ombudsman responsible for overseeing provincial and territorial privacy legislation. Now you see sector specific privacy laws. Some federal and provincial sector specific laws include provisions dealing with the protection of personal information. The Federal Bank Act, for example, contains provision regulating the use and disclosure of personal financial information by federally regulated financial institutions. Provincial laws governing credit unions typically have provisions dealing with the confidentiality of information relating to members' transactions. Most provinces have laws dealing with consumer credit reporting. These acts typically impose an obligation on credit reporting agencies to ensure the accuracy of the information, place limits on disclosure of the information, give consumer the right to have access to and challenge the accuracy of the information. The presence of other privacy related legislation does not always mean that PIPEDA does not apply. Okay, that brings us to end of this presentation. I hope you would have found this information useful. If you like my videos, please subscribe to my channel. Thanks for watching. Bye bye.